Remedies.
I would like to reserve 5 minutes for voting on it.
Thank you.
May it please the court. My name is Brian Staten. I'm the trial counsel and appellate counsel for Pro-Way Paving Systems. We have 2 issues on this appeal, 2 separate statutes. The first is the Florida Motor Vehicle Repair Act, and the second is the treble damages following the stop payment of the check. I would like to address both. The important part, let's start with the chronology. It is slightly confusing when the trial comes through and the evidence that was admitted at trial. But both the quotation for the Peterbilt repair and the invoice are both dated November 4th. That was a Thursday in 2010. On November 11th, exactly 1 week later, is the date that the check for $6,250 was written or printed by Pro-Way to Florida Diesel. The evidence is that the truck was either picked up on Thursday or Friday, November 11 or 12, and the stop payment notice was issued on Monday, November 15th. The way the Florida Motor Vehicle Repair Act requires it is the best practice is to have a written estimate. That's what's supposed to happen. There is an exception, however, for when somebody else other than the customer brings the vehicle to the shop. That there's an implied waiver of the written estimate, and that's found at section 559.905, subsection 1.5. It's also important to look at the definition of who the customer is. The definition of a customer is provided in 559.903, open 1. A customer is the person who gives written repair estimate or any other person designated by that customer on the written estimate to whom they authorize work. We don't have a written estimate signed by anybody. What we have at best was an emailed quotation after the work was done to the accounts payable clerk at Pro-Way Paving. The testimony was very clear through all the witnesses that there was only one person involved in this transaction for Pro-Way who could authorize the extent of the repairs. That's Mr. Rob Volmer. Mr. Volmer was the only person who was the customer. So when his mechanic at the time, Darrell Quinn, brought or accompanied the towed truck, Florida Diesel, it remained Mr. Volmer who was the only person who could authorize the extent of the repairs. So the truck is towed to Florida Diesel. They do the diagnostic work. They figure out what needs to be done. And there's a choice. We can either take this engine out, flush out all the broken pieces in the oil that's distributed, or we can get you a new engine, some type of new engine. Basically, there's 3 different types of engines. You can have a brand new out-of-the-box engine. They sell them out of the box. You could have a rebuilt engine, which means it's been completely overhauled.
And walk me through the price differential between each of those.
Sure.
The used engine was about what? $6,000. How about the rebuilt engine?
If you look at the testimony of Mr. Moya, who is a third-party non-involved, he gave a quote of $6,000 for a used engine. That was
used. That's used. How about a rebuilt? The rebuilt.
Rebuilt, it was estimated between $12,000 and $15,000.
Okay.
That was Mr. Knapp who said that he would give a rebuilt engine for $12,000, $15,000. Here, what they got was a salvaged junkyard engine for $6,250. And that's just the quote for the engine itself, the motor itself. That doesn't include anything else. No parts, no labor, nothing else put in other than that's what the junkyard was going to sell that motor to Florida Diesel for.
Okay, and let me get you back then. I know you're talking about the actual Motor Vehicle Act, but would you agree with me that you can waive the requirement of that act, correct?
Absolutely, Your Honor.
Okay.
Absolutely.
How about in the facts of this case? Wasn't there some sort of information in the course of these proceedings that Mr. Volmer himself had verbally said, okay, go ahead and do it. I'm in a rush. Let's get it done. Let's get it done. Wasn't there something like that here? Okay.
Absolutely.
Why would that not be a waiver of the requirement of the Motor
Because you
Vehicle
have
Act?
to talk about the price. You can't just say, open-ended ticket, go out, do whatever you want, charge me whatever you want. You have to agree upon the price. And I'm referring exactly to 559.909, open print 1. After the diagnostic, and this is in the case of an implied waiver, okay? And you get the waiver of the written notice, meaning that anybody other than the customer agrees to be able to. All right? So that's what we had. We had an implied waiver of the written estimate. And then the statute says after the diagnostic work is done, then the shop has to communicate the additional repair work and the estimated cost thereof. Right? And then the customer then has the right to authorize, modify, or cancel the order.
Okay, and having said all that, wasn't there also evidence presented that in this case, Mr. Vollmer, in past, this was the manner in which that he would handle this, where he would go in, make that verbal okay, and not require a written estimate?
No. What there was evidence of, and it came from Mr. Moya, is that he would get a written estimate and it'd be approved.
Okay.
The statute explicitly says you can do it by telephone, telegraph, mail, or any other means. So Moya was, his exit was very different. It actually was cleaned up better than the transcript in the actual trial.
Okay.
But what he testified to when it comes out of the record is that he would get the vehicle from somebody else, he would give a written estimate, and then he would talk about the written estimate to Vollmer, and Vollmer would approve it. But we don't have that written estimate that was ever given before the work was done.
So then my question then would be, does the Motor Vehicle Act, and as I understand what occurred in this case is that the judge was a bit concerned with the fact that after the stop payment was made, it appears that Diesel, they were trying to work it out with Mr. Vollmer, bring it in, let's see what we could do to try to add whatever it is that was missing, try to work with him, and that 2 years later, by the time this lawsuit proceeded, by the time the judge entered the ruling, that there never once was there any type of mitigation of damages, that never once, he still has the engine, still has the truck, all of that. So with that backdrop, does the Florida Motor Vehicle Act trumps all of that?
Absolutely. It's statute. It's statutory.
So basically, with that statute, I could sit and basically do absolutely nothing and then come back later on and say they failed to do that and therefore I should prevail in this case.
Two-part answer.
All right.
First, the stop payment was issued by Pro itself without advice, but you can see that lawyers got involved within a month. All right. The first demand letter was dated December 13th from Ms. Shaughnessy, and my response came out a couple weeks or shortly thereafter. All right. So lawyers were involved. I was very acutely aware of the Steen versus Morris case that flat out absolutely says if there isn't a written waiver, if there isn't a written estimate or a waiver and authorization, that you can't keep those repairs without paying for them. That's what the case says. Here's the second part of the case, of the answer. If you look very closely at the legislative history of the Florida Motor Vehicle Repair Act, the Steen case came out in 1986. The statute was amended afterwards. All right. And I can't, online, I can't get back far enough to the 1993, 7 years later, after the Steen amendments. It all goes back to 98. But when you pull up the 1997 version of the statute, there is a new provision that fixes this. All right. But it was never part of the trial, and it was never met. I'm referring explicitly to 559.921. That section itself is the remedies goes. And if you go to subsection 7, I'll look right out of my statute as personal notes. If in any proceeding brought pursuant to this part, it is determined that the repairs and costs thereof were in fact authorized, orally or in writing, the repairs were completed in a proper manner and the consumer benefited therefrom, then the enforcing authorities may consider such factors in assessing penalties or damages and may award the reasonable value of such repairs. So, I was acutely aware in November of 2010, by December, a month later, that Osteen v. Morris says if you don't get this written waiver, if you haven't authorized the price, and what Mr. Vollmer authorized was in no way what the invoice or the quotation was.
But you know, it's kind of interesting. He did pay. He got the invoice and it was emailed. He ended up paying the $6,200. So doesn't that, in a way, he was fine with the price, no issue, because the whole purpose of the Motor Vehicle Protection Act, I think makes sense, is that for those of us consumers who know nothing about cars, and I'm one of those people, that if I take my car in, I don't want somehow that for something that would cost $3,000 to repair that I'm not, that I'm thinking it's going to be $100, I get a bill of $3,000, I have to pay that. But that's the whole purpose, to let people know where that estimate of the repair cost would be.
Correct.
But in this case, by virtue of the fact that Mr. Vollmer ultimately paid, I mean, the email came out, $6,250, paid a check, so doesn't that become like a non-issue?
Well, again, Your Honor, 2 points. First, who did that email go to? That's why I read the definition of the customer. Right? It did not go to the customer. It did not go to someone who was authorized in writing by the customer to authorize repairs. It went to an accounts payable clerk. We don't even know her last name. She's no longer an employee of Road. She wasn't at the time of the trial. So that's not implied consent to the invoice because she wasn't the customer. There's only one customer by the statutory scheme. All right. Second, to get back to your question as a consumer, if you look at 559.909, it talks about what happens if the estimate is going to be exceeded. And there is a procedure for it, all right? It says, in the event that the written estimate only is for diagnostic work, B, a determination that the actual charges are going to exceed the written estimate by more than $10 or 10%, but in no case $50, or C, that you've got this implied partial waiver because somebody other than the customer provided it. Then the customer shall be promptly notified by telephone, telegraph, mail, or other means an estimated cost thereof. This can work. I would submit that since this amendment to 921 got admitted, so you can still end up paying a reasonable value, but that's why there's not a lot of case law on the Florida Motor Vehicle Repair Act since the late 1980s. There are some. It was cited by the Southern District of Florida Federal and Bankruptcy Court, where there wasn't a written estimate in 2010, for instance. So the case is still out there, but you really have to dig into the legislative history to see that now you can award a reasonable value. But at no point did they ever tell us, there's no part of the trial where we were talking about the reasonable value. All we talked about in the trial was, here's the invoice payment. There was never an approval of that estimate.
Let me take you back one step from what I'm seeing from the transcript and everything. Maybe you can help straighten me out. I'm gathering that what the trial judge is saying, I'm gathering this, is that he did not find Mr. Vollmer to be credible. And he relied on the testimony of Mr. Moyer and the other company, that in fact there was a conversation and the quote was going to be X amount, and Mr. Vollmer said, don't send me anything, just go ahead and do it. So I'm gathering the judge said, there's a waiver. Now let's move forward from there. How do we handle that?
You still have to have an agreement on the price. You still have to have an agreement on the price. Yes, there's a waiver of the written requirement. I'm understanding Your Honor's question. We're not arguing that the written requirement wasn't waived. But you have to have some evidence of what the price was going to be.
Well, and correct me if I'm wrong, But didn't Mr. Moya testify that he had sent a written quote, and Mr. Vollmer did not sign it, called him up, said, just go ahead and do it?
Well, I'm a little confused about what you're asking, because Mr. Moya was involved for this particular engine, this particular motor,
Right.
and he quoted $6,000 for a used engine. That was Moya's testimony. Mr. Vollmer said the same thing.
Okay.
Moya offered me $6,000 for a used engine, but Florida Diesel offered him a quote of $7,500 for a rebuilt engine.
And how much was the check that he wrote? Or he signed?
$62.50.
$62.50.
Right. But the invoice is for $11,000 and almost $500. There's no evidence from anybody that ProWay agreed to an hourly charge and an hourly rate. What was included or not included. What ProWay testified, what Mr. Vollmer testified to, is he agreed to $7,500. And then, so he wrote a check, and Daryl Quinn, the ex-mechanic, also testified that the price of the part, the major part of the motor, is going to be $62.50. So, yes, when the truck's done, Vollmer says, well, I know that that motor costs $62.50, so that's why he writes the check. He never testified that he did or didn't look at the invoice or the quote. Judge Bergman just assumed that it must have been attached to the check or he would have never signed the check. Well, this is all in a week. And he had a conversation with his employee at the time who said the cost of the motor is $62.50. So he writes a check for the part, gets the truck back to his yard, and it won't start. And then he opens up the hood and finds out that it's, well, actually he spoke to somebody. It wasn't a rebuilt engine that comes shiny and new and painted and pretty. It was a junk engine. That was the quote, directly out of Mr. Vollmer's testimony, because his driver wanted to reset the odometer. And the guy at Florida Diesel says, you can't do that, you just got a junk engine.
But isn't it then after the fact what the court heard, that I can't pronounce, is it from testimony from Angela, is it Nashfor? Napfor. And that Napfor, that after, when your client discovered what it was, they were trying to say, what can we do? What can we do to make it better? And wasn't there some testimony that Mr. Vollmer indicated to her, I know the court system, you're not going to get anything out of me, I'm going to delay this, I'm going to do whatever I can. And then ultimately, he still has, all these few years later, still has the engine, still has it, without any mitigation of damages.
There have been attempts.
Okay, where?
Correspondence with the attempts. That's why both lawyers put in their letters into evidence. They wanted the engine delivered to, the first letter says deliver the engine to Ms. Shaughnessy's office. 1,000-pound piece of equipment. And my response was, no, we'll go to Mr. Moya's, we'll do it in a neutral place. And then, before this got finished, guess what? There's a criminal complaint going on. That's why the detective Lingo testified. So, or he had some problem. 5 minutes.
Yes, sir.
Total or for.
No, I forgot to warn you. It's my responsibility, so I'm not penalizing you for my failure.
Well, so there's a criminal complaint, and nobody ever told Vollmer that the criminal complaint was over. That's straight to the detective. Let me address so I don't waive the issue very briefly. The fraud. Judge Bergman never found a contract. In his dictated findings, he didn't find ProWay liable for the breach of contract. He did tell him that he's liable for an open encounter on unjust enrichment. All he did was say, you stopped payment and then you didn't settle the case, you must have had an intent to defraud. Well, the case law is very clear that you judge the intent to defraud at the moment the stop payment's made. It doesn't matter what happened 6 months or a year later. If you're trying to find out if somebody had an intent to defraud, you have to look at why he stopped payment on November 15th. And the testimony was undisputed. It's because the truck wouldn't start. As reasonable consumers, I ask you, what would you do if you wrote a check for $6,000 for a repair and the car didn't work? You'd stop paying. Take the rest of the time for work. Thank you.
May it please the court. My name is Mara Shaughnessy on behalf of the appellee, Florida Diesel, a Florida limited liability company. I also represented them at the trial level. The first argument is that the Florida Motor Vehicle Repair Act was implied with, and my argument would be exactly as suggested, that there is an implied waiver when the truck was delivered to Florida Diesel for repair by being towed in. Mr. Darrell Quinn, who was pro-A mechanic, had the vehicle towed in. He was there, if the record reflects, he was there for most of the repairs. He was running to get parts. I mean, this is their own mechanic watching all the repairs, not all of them, but most of the repairs, and going back and forth to get through parts. Now, the evidence showed that, or the record showed, that there was an email to Chastity. Granted, we don't have Chastity's last name, but Mr. Vollmer did testify at the time that he was Florida D, or that she was pro-A's account payable person. I mean, this is a business. Who would an email quotation be sent to? It would be sent to the account payable person. And then Mr. Vollmer signs a check. He testifies at trial that he signs a check that also has to have his partner's approval because it's over $1,500. So they already have a safeguard in place to make sure that things that are paid should be paid by having two eyes look at it. So they have two eyes look at it because it's a $6,250 check, and yet neither one of them stops to say, where's the quotation? And the quotation number is written on the stub of the check, and that was entered into evidence. So Mr. Vollmer sends his mechanic with a check for $62.50 because there's evidence that he was, or record report that he was told, Darrell Quinn told him that Florida Diesel was not going to release the truck until they got payment of $62.50. So he sends his mechanic with a check for $62.50 and gets the truck, and then consequently stops payment on the check. The remedies in the Florida Motor Vehicle Act are very clear. Mr. Vollmer should not have stopped payment on the check. He should have registered bond with the court to say, I believe I've been violated by this act, and I need the court intervention if he wanted to get his truck back. He should have given this $6,250 check if he didn't agree with the quotation and the invoice.
Is it correct that by giving up, providing the check, the mechanic, the person who work, gives up their lien, the right to hold the vehicle as collateral for payment?
Yes. But instead of taking that remedy, he sends a $6,250 check to his mechanic and then stops payment on it. Under the Florida Motor Vehicle Act, under section 559.921, it lists the remedies, and the court addressed this in its findings, that any customer injured by a violation of this part may bring an action in the appropriate court for relief. The prevailing party in the action may be entitled to damages plus court costs and reasonable attorney's fees. The customer may also bring an action for injunctive relief. Now, Mr. Vollmer did none of these. He did not file an action. If he's what he believes an aggrieved party under the Florida Motor Vehicle Act, his relief was to bring an action. And then, as the court pointed out, once Florida Diesel files an action, Mr. Vollmer doesn't file a counterclaim. He merely uses this as an affirmative defense. And opposing counsel argues that the judge didn't directly consider the Florida Motor Vehicle Act in his ruling. But he did, because there was a great deal of talk about chastity, the estimate which was different than the invoice. The estimate was dated November 4th. The invoice was dated November 11th. The email was sent on November 8th. The check was dated November 11th, etc. On the second issue, on the intent to defraud, it's very clear, and the investigator testified that Mr. Vollmer stated, and the record states that said to Angela Naper that, go ahead, sue me, I know the law, I'm gonna tie you up, etc. So Mr. Vollmer canceled that check on the 15th of November. The stop payment was issued. He had no intent to pay for that motor. He got the motor. He continued to drive the truck, the record reflects, for several years. If this was such a junk motor, why was it still operating for several years? He testified all the problems that it had for timing, etc., glow plugs, things that I've never heard of. And yet he never paid or had it taken to another person or didn't provide any evidence of all these supposed expenses he had for this junk motor. Even when the investigator talked to him about doing things like returning the motor or doing things like that, he said actually that he was going to do so, but he never did. Correspondence did go back and forth between the two attorneys' offices, and it was never agreed upon that he would return the motor. And incidentally, it's interesting in the response to the amended complaint by opposing counsel, he lists all of the, as part of his affirmative defense, he lists all of the charges that ProWay had for replacing the motor. Well, ProWay never replaced that motor. They actually still have that motor in the truck, or did at the time of trial. I don't know if it's still in the truck today. So therefore, it's our position that the ruling of the lower court was correct in that the Florida Motor Vehicle Act was complied with. There was a partial waiver and then an implied waiver, and also that ProWay did not use the proper remedies as were listed under the Florida Motor Vehicle Act. Instead, they took what I would consider self-help remedies, and then they stopped payment with the intent to defraud.
Thank you.
You have 4 remaining. Counsel, before you go into your prepared remarks, or just before you go into your remarks, I have a question. In the pleading, you assert the statute as an affirmative defense, and generally an affirmative defense admits liability and then avoids it. So, what exactly were you admitting by the use of that statute? That you owed the money, but you avoid payment because of the technicality of not complying with the statute? What exactly was the admission? What exactly was the avoidance?
The avoidance was you don't have a contract because we never agreed upon the price because you never got the authorization from the customer.
Okay, so what were you admitting?
That work was done.
Okay.
That you put in a used junkyard engine when it was supposed to be a rebuilt engine. But let me also address that, Your Honor, as the counterclaim. A lot of it has been made about this starting with Judge Berg. Well, first, the statute says that I may bring an action. It doesn't say I have to in order to.
I just want to make sure I understood what the context was of the admission and the avoidance.
Well, okay. But here's the second reason why we never filed a counterclaim. I'm reading straight out of the Osteen v. Morris case. I had motor vehicle repair cases before this. All right? This wasn't the first time I looked up this act. It wasn't the first time I'd heard this case. So I'm quoting directly from page 1289. The customer's only injury is that he paid the shop for services for which he was not liable due to the shop violating the act. We didn't have that injury because we stopped payment. The statute says, or the leading case regarding the act says that you only have injuries if you paid the shop. We didn't pay him. We stopped payment on him after we found out there were defects in the work. That's why there was never a counterclaim. So it was an affirmative defense saying we don't owe you the money because you didn't do what we want, what our authorization was for, and 2, you didn't. The price was agreed upon to be $7,500, not $11,489. What other type of damages could we have? Well, let me correct the statement. We did put on evidence of other repairs. That's why Mr. Moyer was there. He talked at some length about a cracked head. Well, cracked head is what sits on top of the valve covers. That's absolutely part of the engine that was put in there by Florida Diesel. But if you look at the invoice and the quotation, it says a 100-day warranty. We were almost 2 years out. So we did put in evidence of repairs. The other thing you have to remember is Daryl Quinn, the ex-employee, was a mechanic, an in-house mechanic. Mr. Vollmer also testified that they didn't keep track separately of which vehicles the mechanics and the in-house mechanics worked on. It all went into a hole. If you look at the transcript, it's misspelled. They used a W instead of an H-O-L-E. It's W-H-O-L-E. But he said it went into a hole. So we didn't track it. So I didn't have any proof of that damages. What I did have is defects from everybody. Everybody knew the electronic control module had to be reflashed to get it to start, and it continued to have problems with restart. And again, let me reiterate, what else does a consumer do? If you think this is what the contract says, and you get something that violates, do you let them have their money? Well, if the check hasn't cleared, that's why the UCC allows for a stop payment. So then you can negotiate the price. That alone, just because you issue a stop payment, doesn't mean there was intent to defraud when the stop payment was issued. In sum, Your Honor, I did everything I could to invoke this act. It's part of the original case. I had prepared a motion for voluntary dismissal and I argued it writing in the law to go to trial. I had a memo of law trying to tell Judge Bergen that this is why we're not liable, and it was ignored. Judge Bergen didn't make a finding of contract. He didn't make any findings on unjust enrichment or open account. He didn't establish what the reasonable value of the repairs was. He just was mad because we were trying the case and we didn't get it settled. That's not the law. We invoke the Consumer Protection Acts of 559, 09, etc. And I ask that this court enter an order saying that we're liable only for that threshold amount, just like it happened to those.
Thank you.
Thank you.
Thank you all.
That concludes our docket today. Court is in recess.